And a gun, but never mind.
Oh. Oh. Well, I appreciate that. Oh,
They're suing him because they're mad.
hold on.
Tell them you're innocent. Oh!
Alrighty. I've looked over all the evidence, the testimony, as well as the applicable laws. There's a number of things to unpack here, so bear with me. So I'm going to refer to my handy dandy flow chart. All right, so the first question in this case is, was Minerva Mott acting as a civilian or a police officer in this circumstance? I take, very seriously Mr. Braun's assertions regarding sort of the tenuous nature of off-duty versus on-duty officers at times and how may they act, what guns they may carry, things like that. If, for example, she had her class 2 on her back still, that might sway me in a certain direction. If she had issued formal commands, that may have swayed me in a certain direction. She had taken identifying action, identified herself as senior deputy, all those sort of things that regardless of whether she was on duty or not, that would change the character of the situation. In this situation, we don't have that. We have some vague sort of question about what gun she was using. There's no real evidence or testimony to be had either way. Even Mr. S couldn't really identify it was just a pistol. She had no markings alleged to be on her person or her vehicle. Didn't identify herself as a police officer, didn't take any formal action as a police officer, and I'll get into that more in depth. So for my, purposes on initial, first blush, I don't believe she was acting as a cop. However, just to indulge the arguments and to examine sort of, the fireman's rule, there are some questions about, even if she was acting as a cop, does that prevent her from retaining any kind of right to sue? There are different treatments of the fireman's rule in different jurisdictions. It also has different exceptions to it. For example, like if you're a fireman and you go to fight a house fire and you get burned, you can't sue the owner of the home, right? But if you, are running to get to the back of a warehouse to put out a grease fire in the kitchen, and famously, I think this is in one of the cases, there's no anti-slip floor protection or non-slick coating, then you actually could sue. Another example could be if someone set the fire on purpose, you could sue. So there are distinguishing factors. There are exceptions.
Chap.
I'm not going to make any ruling or any kind of precedent here
we
today
tee it
on
up
the
like
fireman's
Mickey's
rule and how we
fucked, but
treat
then
it in
he's
this
not fucked. We'll
jurisdiction
see.
in those exceptions, because I don't think she was acting as a cop. Therefore, it wouldn't be prudent to do so. Now, if she's acting as a civilian, there is a secondary argument made by Mr. Braun, which I think is pretty poignant here, which is that, she was acting as a negligent civilian. So we examine things all the time about stand your ground and how people should act. I myself have been in many, many scenarios in the courthouse where I've been, thinking as I do on the second floor of the courthouse behind the pillars to hide from people because I'm dealing with something important. Please don't start bothering me up there because I've now said that. And I will observe someone run into the courthouse, hold someone up at gunpoint as a hostage or for some other nefarious plot, like Chatterbox may want to kidnap somebody. Dundee may come in and ask, for a clerk to give him all of the licenses. And yes, both those things have happened. I think Mel Rickenbacker did the same. And even though I'm not a police officer, I'm just a civilian, the instinct has crossed my mind to pull out a gun because I, have the, epitome of the high ground at that point, and insert myself in the situation. I do not, because upon stand your ground, there are many other steps I have to take before defense of another, including the fact that the threat of, injury to life has to be actualized. The very pointing of a gun inherently is not always a threat to life. It should be considered so, but a lot of that contextually comes down to the demands of the person with the gun, what their status is. and just blindly, me as a civilian or me as a judge, encouraging civilians to then just pull guns and create standoffs, not a great idea. So it's not my personal preference. There are articulations either way. In this situation, I have the following testimony from Miss Mott. She got off her motorcycle to, quote, figure out what was going on, and she had her firearm out. She states she doesn't know why she had it out. She states, it wasn't her intent to do anything with the firearm, but nonetheless, she had it. When asked on cross-examination what her intentions were, she stated it was her intention to figure out what was going on, try to stop it in general, but that it wasn't her first intention. Now, again, this can be argued under the lens of defense of another, stand your ground as a civilian. This can be argued, as Mr. Braun did, that her cop instincts were kicking in. I can kind of merge the two. I can see an argument that, she was a civilian who had certain instincts. There are civilians with military backgrounds, with security backgrounds, with certain training. Bucky back there, for example, is someone who I've seen, get into situations where he wanted to step in and help someone. I know there's private security companies popping up who are trying to defend people or places of business. I know, like Roosters is trying to have a security company, things like that. So there are questions of, when people should involve themselves, how they should do it. All of that brings us to the following. If, and this is Mr. Braun's argument, so plaintiff don't think I'm just parroting his arguments. I'm examining them because yours are pretty straightforward. You've proven the damages, you've proven what happened. So I'm basically needing to argue inherently in my head against what he's putting forth to see if it, holds water or not. So Mr. Braun's argument was she was acting as a cop, but even if she wasn't acting as a cop, she was acting as a negligent civilian. And the only way that she wouldn't be a negligent civilian by having a firearm out during a standoff with guns held at people's heads is if she was a cop. Okay, so let that sink in. The only reason that someone in a hostage standoff would have the, legal and sort of moral high ground here to pull a gun and involve themselves is if they're a cop. If you're a civilian and you see people with guns held at their heads and you walk up and pull a gun out, that presents kind of a question. And that question is as follows. Is that negligence in that situation? And what does that negligence mean? Different situations and different jurisdictions hold that negligence differently. There's two things here. One is called contributive. One is called comparative. Contributory, comparative. Contributory negligence basically means if you contributed at all to the injuries that you received, such as, let's say, you're speeding on the highway and a drunk driver veers into your lane and crashes into you head on. But because you were speeding, you didn't have as much time to react or move out of the way or brake. You contributed to the accident, even if it's only, 10. And therefore, you don't get to sue. Because you weren't acting, that's an appropriate standard for this. Reasonable? No. The other standard is called comparative negligence, which is where you take sort of each person's responsibility in the situation. How did they act, and how did that ultimately lead to the end result? How much of it was their responsibility? How much of it was the other party's? In this situation, do I think there was negligence here in terms of Miss Mott? Yes. She openly stated she had no idea why she had a gun out. She stated that she wasn't sure about her intentions clearly. She stated she was trying to figure it out. Then she stated trying to stop it in general, but it wasn't her first thought. There's some questions about who said what, whether anyone could hear anyone else. That kind of stuff I'm not as concerned about. I'm more concerned about the whole, getting off the bike with the gun out. Do I think that any civilian should be held to the same standard of negligence? Yes. Otherwise, it would create a paradigm by which every civilian who sees someone getting held hostage with a gun would just walk up with a gun out, and then if they get shot, they would sue the person who shot them. I think there has to be some level of sort of some level
I have no idea
comparison between the responsibility and the situation. So while Mr. S did take an affirmative action to shoot Miss Mott, and while Miss Jolie was certainly a willing participant in all of this, I don't believe they bear full responsibility for what occurred. I think that I'm going to reduce some of the damages accordingly. So I'm going to find as follows. I'm going to grant the punitive damages. I think it should be deterred for people to shoot other people in the head. I think that's fairly clear. I think in terms of that, you know, they bear full responsibility, right? I'm just going to say that flat out. I think Mr. Jolie and Miss Paul, both as a, you know, an accomplice and as the primary actors, shot people in the head, as Mr. S has so, you know, satisfactorily stated. He shot them in the head with a class 1 versus a class 2. So I'm going to grant the 25K from each party on that note. In terms of the other damages, the pain and suffering, I'm going to combine those two. I don't really know why they were separated. It's just pain and suffering. The pain is the physical pain. The suffering is the emotional anguish and the, you know, effects leading on. I think the amounts are relatively high. I think if you got what you were asking for, you'd be getting 50K plus, what is it? Yeah, you'd be getting close to like 400K or something. I'm thinking that it should be reduced. So I'm combining the two. I'm calling them, you know, 75K total, and then I'm reducing that by the involvement. So I'm going to give the allowance of 25K from each client for pain and suffering as a total amount, which means you'll be getting 50K from each defendant.
From
and
50K,
I'm assessing your comparative
I'll take
negligence in the situation at 50%. So the total award is going to be 25K from each client for a total of $50,000. That's the ruling of the court.
Oh. What?
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
Oh, what a
I don't
lousy.
know. I mean,
So-
he lost like half the fine.
That went from 175K for me to 25K.
You're going to be billed.
Yeah,
Definitely a dub.
That's definitely a win.
Yeah, hold on. Just give me 1 sec. Hold on. I just gotta... Give me 1 sec. I gotta just be in my head for a moment. Just hold on.
Wait, what was this for?
Miss Matt, if you could provide your bank account that starts with a 6.
Yeah, guys, I'll be right back. I just gotta do a quick slow walk out. Hold on. Yeah, that's a win.
Get
Hey,
billed, you can't leave
that's a
yet.
fucking dub in my book. We went from
He was already
175 to 25. Good shit.
Right. Thank you, Crane.
As a lawyer, I think it's disgusting.
61903979.
Do I get money?
And more importantly, chat.
The raffle?
Emote only off. That's a win, chat.
They didn't bill you, by the way. You just ran away. You're going jail. See ya, bozo.
I was billed 25K for it, chat, instead of 175. And remember, that was 25K. Smoke on that PD pack, baby.
Good job.
Go to the octagon.
We smoking on that PD pack, chat. Emotional damages my ass, man. Hold on. Oh, hold on. I have one twat to make. Give me 1 sec.